Hi everybody and welcome to class number 2. I hope that your semester has been off to a good start and that the different classes you're taking, they all appear to hold in store what you hope that they hold in store for you. Today we're actually going to start talking about negotiations. We're going to focus at a very general level, and in the coming weeks we will become much more specific. But today we're going to talk about an overview of what negotiations is, and we'll examine negotiation theory at a very broad pace. If you look at the syllabus, the last page of the syllabus where it says anticipated schedule, this gives a pretty good idea of the overall structure and approach for how we'll be doing things. Last week, of course, we introduced the overall concept of the class. We discussed the syllabus, and you'll see here under week number 2, we're talking about an overview of negotiation and negotiation theory. You'll see the 2 weeks following this week, weeks 3 and 4, we talk about the negotiation process in general, and then discuss strategies and tactics. Now, if you look through weeks 5 through 10, where it says planning, orientation, information exchange, proposals, narrowing the differences, and closure, those topics sort of form one cohesive unit that comprises the overall process of negotiations, everything from planning to closure. And so, as you can see, next week we'll be talking about the negotiation process in general, sort of looking at the whole landscape of that, but then in the subsequent weeks, after a discussion for 1 week on strategies and tactics, we'll be spending an entire week, an entire course session on each aspect of the negotiation process. If you look, there is a mnemonic that goes with this, and actually the way I have it out in the schedule doesn't match this mnemonic. We may switch around weeks, let's see, weeks number 7 and 8, because the mnemonic is POPINC, P-O-P-I-N-C, planning, orientation, proposals, information exchange, narrowing, and closure. So just a helpful way of remembering the overall process of negotiation. But that's not where we're going today. We're going to talk about much more generally some of the things about negotiation at a foundation laying sort of general level. So at the outset here, I want to introduce an important vocabulary term, and that is this idea of transactions. Throughout the semester, you'll hear me using the term transactions to refer broadly to both the resolution of disputed matters and what we ordinarily think of as transactions. You know, you think there's like litigation attorneys and then there's transactional attorneys. And transactional attorneys don't go to court. They work on negotiating contracts, they work on deals and things like that. The sense in which I'm using the word transactions is a little different than that. When we're talking about negotiating a transaction, I'm usually talking about this broader idea of negotiating either a business deal, you know, doing putting a contract together, working out an arrangement, or talking about resolving a dispute. So just keep that in mind as we're going through the semester. The word transaction is a useful way of talking about whatever it is that the parties are negotiating. So hopefully that makes sense. So let's talk about this idea of negotiation as a key legal mechanism, particularly in the area of dispute resolution. An astonishingly small number of cases that are filed, litigated matters, actually make it all the way through to trial. Depending on the jurisdiction, depending on the tribunal, depending on which year you look, it's usually in the single-digit percentages of number of cases that actually go all the way through to a verdict, either from a jury or a judge. 3% is a number that you see a lot. And it presents the question, why is that? Why do so few cases that are filed actually make it through to final disposition by the finder of fact and the concluder of law? And there's a number of factors if you think it through. A lot of the cases are dismissed, right? Either on like a motion to dismiss in federal court, like a 12b6 motion, or a summary judgment motion. It is determined for one reason or another that the case should not go forward, and so the case ends right there, perhaps not at the decision or wishes of the plaintiff. Sometimes the plaintiff will withdraw the case, and that could be because they've run out of money or they recognize that they're not going to benefit from continuing the litigation, or any number of reasons. The plaintiff may actually withdraw the case. The biggest number, though, probably, I don't know if it actually is the biggest number, but I would imagine that the largest percentage of cases that don't make it all the way through to trial don't advance any further because they actually settle. And I would, of course, be a proponent of saying that that's the most important reason cases don't go all the way to trial, because we're talking about negotiations and we're talking about disputes getting settled. So let's focus on that thing for just a moment. What are the key benefits of two parties working out their dispute, settling the matter, coming to a resolution on their own terms? Well, there are a number of them. It's usually quicker. This resolution happens sometime after the complaint is filed, but before you would get all the way through the process of discovery and motion practice and pretrial practice and finally going to trial and going up on appeal and what have you. The resolution of the case can often happen much quicker than that. Another key benefit is implicit in what I was just talking about there. The earlier that a matter is resolved, the less cost there is involved. If there doesn't have to be a whole lot of discovery, if parties don't have to sit for depositions, if you don't have to travel to and from court, especially if there's litigation involving multiple districts or the parties are a long way from each other. And of course, the attorney's fees. That's the biggest part of the resource expenditure that a party in a disputed matter has to worry about. So it's faster, it's less expensive, it often can be more private. The less documents that there are that are presented to the court and made a public record, of course, the more the parties enjoy some kind of sense of privacy, that the sum and substance of the transaction and all the different facts that make it up aren't a part of the public record that everybody can look at and perhaps ridicule or otherwise cause some harmful effect to come to that party. It's more private. And then finally, and this is the key point that I would really like to underscore because it is most relevant to the idea of talking about negotiations, and that is when the parties resolve a matter on their own and they settle it, they enjoy the most control over the outcome in this. If you can imagine, there's a spectrum. On one side, you've got adjudicated matters where the court decides the outcome of the case, and then over here you've got matters that are settled by the parties. And what that spectrum represents is really the amount of control that the parties have over the outcome. Over here, where the parties have negotiated a resolution and have agreed on the terms, they've got the maximum control. And of course, neither party is going to have 100% control because you got to worry about agreeing with the other side, but there's much more control that the parties have jointly in that situation than the situation over here where it's the judge or the jury that makes this decision. And we all know that litigation is an extremely uncertain prospect, and that is because of this lack of control that the parties have on the outcome. So let's talk a little bit about this idea of what is negotiation. And there is this idea that you can gain a lot from looking at the definition of negotiation to really see what is involved, what's underlying the overall process. So if you translate the words making up the word negotiation from Latin, you get not leisure or no leisure. And so this could have a meaning in a couple of different senses. One is the idea that when parties are in negotiation, they are doing business. They're not just laying around, they're not just sitting around, but they are actively involved in commerce in the marketplace. And so it's the opposite of whatever you do when you're not doing that stuff and you're just sort of enjoying the life of leisure. The other sense in which negotiation could have its meaning from those words is this idea of the tension between two parties, two different sides, when they are looking to resolve a transaction. There's a certain uneasiness, there's a certain striving that the parties have with one another when they're trying to work out a transaction. Again, whether that is a disputed matter that they're trying to resolve or whether it is some kind of commercial or other transaction where they're just trying to strike a deal. So until that resolution is actually had, there is a lack of leisure. There is no leisure. And it's that process, it's the state of that, it's the status of those activities that make it not leisurely, and you have the word negotiations. So we use the term negotiation or negotiations frequently, but what does it really mean? We don't think about it too much. We sort of know it when we see it, right? And we've all engaged in different forms of negotiation, whether it be buying something or selling something or just trying to get yourself into some certain situation with someone else. But it's worthwhile to spend some time considering what we mean when we talk about negotiation. You'll remember in our discussion of the readings for this class, in class 1, one of the recommended readings is Professor Gifford, not required reading, but Professor Gifford defines negotiation this way, saying that negotiation is a process by which two or more participants attempt to reach a joint decision on matters of common concern where they are in actual or potential disagreement or conflict. That definition is in the reading materials for class number 2, so don't worry about writing it down if you can look at it there. So this is really helpful. This is useful because in this definition there are a number of aspects, a number of concepts that we often leave out when we are thinking about negotiation in the ordinary sense. But it's helpful to highlight those at this point because it will give us some things to keep in mind as we're exploring the concept of negotiation throughout the semester. So the first one is negotiation is a process. It's a back and forth. It is an exercise in communication. It is information exchange. It is conducting oneself in a certain way as to hopefully get the interest of that party who is doing the negotiating met. Let's not get ahead of ourselves. Let's break down these elements a little bit more because some of the things I just said are in what I was saying just about that first point there. In Gifford's definition, there's this idea that there can be a number of different parties involved, one or more, or I guess two or more parties, right? There are multi-party negotiations, and that is probably more the norm if you think about the different types of transactions that go on in relatively sophisticated commercial life. it's seldom that there is just one party and the other party, a plaintiff and a defendant. There are usually more than one plaintiff, more than one defendant. If it's a transaction, there could be a bank involved, an insurance company, in addition to the business principals involved. And there you have, it could be several owners of a company that are involved in the transaction. So there's a number of different parties, a number of different interests involved. And we'll talk about interests a lot, just a little foreshadowing there. Here's a key concept that we often leave out of our mental concept of negotiation when we're talking about it on a day-to-day basis, and that is there isn't always a deal struck. Gifford's definition says that negotiation is a process by which two or more participants attempt to reach a joint decision. So it's worth considering this idea that negotiation can happen even if you don't come to a deal, even if there's not a closing. It doesn't mean if you didn't get to a resolution or close the deal or finish the transaction or what have you, that you weren't negotiating all along. So it's important to remember that negotiation is happening even if there's not something final that comes about. And then finally, worth highlighting from the Gifford definition is this idea that the subject matter is of common concern. And so it doesn't mean that that both of the parties' interests are aligned or that they both have common objectives in all of this, but they certainly are both concerned. They both have the desire to see this particular transaction resolved in a particular way. Each party is going to want to have it resolved in a way that matches and meets its interests best, but that doesn't mean they're not concerned about the same overall subject matter of the transaction. So that is the idea of the definition of negotiation. This is, on this idea of the definition of negotiation, this is why it's critical, it's key for you to see alternate perspectives of negotiation than what you're just getting from this class. And so remember, part of the assignment throughout the semester is to be selecting another book about negotiation of your choice, so that on these key concepts, like what is the definition of negotiation, you'll see alternate perspectives as you're reading that work. My view and the way I'm showing it to you, sort of channeling Professor Gifford here, is one approach. I think it's a reasonable one. I think it's a sensible one, but it's not the be-all and end-all about how we ought to think about negotiation. So what does it take to successfully negotiate a transaction? The way I present that question, it's like we talk about a couple of points here and then you've accomplished everything you need to do in this semester, right? How do you do a successful negotiation? Well, there are just a couple of things. There's the right knowledge and there's the right approach. There you have it, right? We can stop for the semester, but clearly there's much to unpack from those things. On the idea of having the right knowledge for a negotiation, that breaks down into a couple of subheadings there. You want to have the appropriate factual knowledge, and this on this concept or this idea of you working as legal counsel for your client, working to negotiate a transaction, the idea of the appropriate factual knowledge is simply knowing the facts that your client presents to you and those facts which you can easily ascertain related to the transaction. So, in the typical hypothetical situation, you got the client coming into your office, maybe in the days of a global pandemic. That hypothetical doesn't, or that context doesn't work as well. But you have an initial phone call with your client or exchange some email. They're going to be telling you the facts of the situation. Look, I'm working out this deal. I want to enter into a contract with this party to sell these goods or provide these services, and here are the major deal terms. Or I'm a plaintiff. I'm an injured party, and I want to sue this negligent individual on the other side, and here's what I want to recover. It's just the fact gathering, the facts of the transaction. And clearly, for you to be an effective help to your client in the context of legal negotiation, you got to know very thoroughly what the facts are. Really nothing more to say about that. You've just got to know what's going on, and that is factual knowledge that is necessary for a successful negotiation. Then, of course, under this heading of knowledge, is the idea of substantive knowledge. You need to know what the law is. You need to be able to identify the issues so that you can help your client identify what his or her interests might be and what kind of approaches might be the right way to the right, identify what the right approaches may be in the situation. And it could be even down to this idea, this would be a form of substantive knowledge of just knowing what the court system is like and whether you should try to bring the matter in front of this court versus some other because of some advantage or disadvantage that you may face if you do that or don't do that. So that is what I mean by substantive knowledge, and that's something that's special to legal negotiations. So then there's, like I said, to be successful in a negotiation, you need the knowledge and you need the right approach. We really won't say a whole lot about the right approach here in this lecture because that's what we talk about for the remainder of the semester. It's up to you to get the right knowledge about what a particular transaction is. It's this course, it's what we focus on is the overall approach. And what I mean by that generally is, well, what is the right kind of strategy to take? And we'll talk about strategy in a lot of detail. It could mean, how do we make sure that the process goes the right way? And so that's what I mean by approach, choosing the right approach, executing on the right approach in the overall context of the transaction. So knowledge and a right approach, put those two things together and you've got a successful negotiation. So then let's now, in conclusion, talk about some of the special attributes of legal negotiation. What does that mean? Well, we know about negotiation in general. Everybody does it. Whether you are even quite introverted or what have you, you've still got to engage in everyday life and there are negotiations to be had. So everybody negotiates at a certain level and in certain contexts. But since this is a law school course talking about negotiation, let's talk about some of the special attributes of legal negotiation. And these are outlined in the reading materials, but let's talk about them here. The first one is that legal negotiation involves special knowledge. You are legal counsel. You presumably, if you are practicing competently, know about the areas of law that may be implicated and have a certain skill in counseling your client and in interacting with the other side. So those are special traits, those are special skills that one brings as legal counsel to a legal negotiation. Another unique attribute of legal negotiation is that you're not negotiating on your own behalf, but you're negotiating for your client. And this can be a way that the negotiation is done in a way that is perhaps more objective, because if you're negotiating for yourself and on your own behalf, you often place your own interests in the front and center in such a way that it's not useful because you lose sight of what might be effective strategies or effective tactics in the overall process of the negotiation. So the fact that you are negotiating on behalf of your client is a way in which you as legal counsel are bringing special value to the transaction on behalf of your client. And then in another related way to that, the lawyer serves as a buffer. And this is particularly important in those transactions where the parties have a lot of emotion, maybe a lot of bad animus between them or among them. And it could be that the parties despise one another and don't want to interact directly at all in any way whatsoever. Well, the lawyer and the two lawyers working together in an ideal world, and I say that with a certain tongue-in-cheek aspect because oftentimes lawyers working against one another don't get along at all. But in the ideal situation, those lawyers sort of serve as a buffer and diffuse or dissipate or somehow reduce the intensity and the virulence of those bad sentiments that the parties may have for one another. So the lawyer serves that key role, and that's one of the things that makes legal negotiation special, is that you've got legal counsel involved in that, and they serve as that buffer. And finally, to wrap things up, remember I promised there wouldn't be a whole lot of substantive law in this class, but we will at some point talk about the rules of professional conduct, and that is something that is unique to legal negotiation, because as lawyers, you're doing a lot of communication to other parties on behalf of your client. And so that could be you talking to the other lawyer in the case. It could be you talking to the other party directly. But if you've studied the rules of professional conduct or have taken the MPRE already, you know that that might be problematic. You may have to talk to the court, right, about these things. And so the rules of professional conduct do indeed apply to you and to your conduct in a legal negotiation. You've got to follow those rules and particularly be aware of how they deal with what you say, how you say it, how true it is of how true it is, the thing that you are saying. And that's something that's special about a legal negotiation, because you as legal counsel have to abide by those rules when other people in other contexts, just in broader general commercial negotiation, don't have to worry about those things. We'll spend an entire class session talking about ethics and how those apply to the concept of legal negotiation. So that is it. That is the subject matter for class number 2. So I will look forward to discussing these with you live on Zoom. If you have any particular questions, feel free to bring those up when we're all together. I'll go over this content again very briefly, just sort of touching on the high points to kick off any discussion that you may want to have. But as always, if you would like to talk to me directly, send me an email or give me a call or send me a text. My door is always open, metaphorically speaking, these days. So take care, and I will talk to you soon. Thank you.